Welcome to It's a Crime. I'm Linda, and today we have another update on the Lori Vallow Daybell case. But before I get into it, if you'd like to be part of the It's a Crime community, please click that subscribe button below, hit that notification bell, also give it a like if you support this, and please share this out where you can. Now, let's get into it. Well, Lori's pleading not guilty to her charges, and as always, Lori's looking to get her bond lowered yet again. We saw this in Hawaii, we also saw this when she first arrived in Idaho, and now she's going to take another crack at it. I feel though this one might be just out of urgency since, time's running out, we're on the clock, and we have less than a week before it hits July 22nd. And I have a feeling that Lori still has a to-do list of things that she needs to get done before this date. And I'm not forgetting about Chad either. Chad's included. In fact, Chad is known to like his listicles. His zombie list, lists of things they need to accomplish together, hit list. They just have a little snafu and are in a pickle at the moment because they're stuck behind bars. Now, in a court document that was filed, it first shows her plea of not guilty to counts 1, 2, and 3 of the amended complaint. Also, it asks for a pre-trial and jury trial. It says defendant enters a plea of not guilty to count 1, 2, and 3 of the amended complaint filed in this matter. Defendant demands this case to be set for a pre-trial and jury trial. And Mark Means asks for Lori's bond to be lowered, like I mentioned, and also asks for a change of venue. Here's what it says about the bond. Defendant asserts felony charges regarding previous bond setting were dismissed, and as such, bond should be reset to reflect current charges evident in the newly filed amended criminal complaint. Defendant requests this court to review applicable criteria under criminal statute and criminal rule as it pertains to bond reduction. The defendant respectfully requests oral argument on this motion before the Honorable Judge Mallard. And I was watching Scott Reich this morning from Crime Talk, and he was pointing out some interesting things about this document. I will leave the link to Scott's video below. I love that he calls Mark Means somewhat confused. His direct quote is, "Once again reinforcing my opinion that Mr. Means is somewhat confused." So you got to check out that video. Now, in his video, he mentions that some of the things he sees in this document are things he's never seen before. And for Scott to say that, who's been in this for 25 some years as being a defense lawyer, well, that's saying something. So there's a section that they talk about affirmative defenses. And again, back to Crime Talk, Scott says, an affirmative defense is, I did it, but I'm excused for these particular reasons. He says, some of these very creative reasons that Mr. Means has come up with are things that I never heard of. He says Mr. Means is more of a civil attorney than a criminal defense attorney, and talks about how that seems why these items are listed the way they are. Here's the court document. It says affirmative defenses. Number 1, court lacks jurisdiction, re personal jurisdiction. 2, court lacks jurisdiction, re subject matter jurisdiction. 3, improper service of process. 4, defendant did not knowingly violate any order. 5, inability to comply. 6, in regard to count 1 and 2 of the amended complaint, the solicitation and or resisting and or obstructing an officer is a lesser included offense of the other as they the same set of pertinent facts. Number 7, defendant expressively reserves the rights to assert additional defenses once the state has complied with discovery requests in these cases. And 8, defendant in no way is waiving her Fifth Amendment right against self-incrimination by assertion of any and all affirmative defenses. Now, there is a pretrial conference taking place remotely tomorrow, which is Friday, July 17th at 10:30 a.m. Mountain Standard Time. You can access this by telephone or video conference. They are using Zoom. So some of my Crime Ring members, you are familiar with Zoom. Here is the information. Time is ticking away for Chad and Lori, and I do wonder where they are on their list of to-dos before this July 22nd. And who's helping them prepare for these upcoming days? That's an important question. Maybe Lori is taking a page out of Letitia's book and measuring herself and, trying to find a broomstick that she can ride out of jail with. And we know Chad already has his portal potty, and perhaps he can give it a whirl, before the 22nd of July. It's not too late, Chad. Let's have a chit-chat below about this. I know some people aren't going to be very happy, but let's have a chit-chat. Let's see what happens also tomorrow, and I'll be updating you with that. Please like, please share, and please subscribe. Thank you so much for watching. See you soon.